welcome to this event on navigating change and the Employment Rights Bill. I'm Sonya O'Reilly, and I'm going to take you through the session today. I'm a partner at Birketts, focusing on employment law and specialising in that area of law for the last 25 years. So there's lots of things that change all the time, but actually what we're talking about today is an area of change which is really quite seismic, and it is quite generational change. So it's great that you've joined today. There's lots that I can share with you. In case you don't know anything about Birketts, just a little bit of information about us. We're a full service law firm. We've been around for a long time now, so our heritage spans over about 160 years. We're based across 7 locations in the United Kingdom, but for the east of England and for the purposes of the Suffolk Chamber of Commerce, I'm actually based out of our Ipswich office, and I represent the Suffolk contingent of the firm. In terms of employment particularly, I thought it'd be useful for you to see the strength and depth of our employment team. So you can see there that there are a significant number of us that specialise in employment across all of our offices. And we also have various other resolve support that we put alongside our employment law practice, and that's to try to help employers really navigate change and to support them with resolving disputes within the workplace. So as you can see, we've also got immigration specialists, we have investigations specialists who are able to go into an employer and to help manage with any investigations that might be required, perhaps under a grievance or a disciplinary process. We have HR consultants. We have a team of people that provide training for line managers and for organisations to help them understand what their obligations are as managers, and that's under our Shaping Excellence programme. And we also have a team of employee incentives lawyers and advisors as well. So without further ado then, let's look at the Employment Rights Bill. So this is the flagship policy, really, the flagship piece of legislation that the Labour Party talked about in their manifesto. So when they were campaigning for election to government, they really talked about trying to improve workers' rights and employment rights. It's an area that the Labour Party have always historically been very keen on anyway. And so it wasn't perhaps surprising that employment was going to be one of the areas of their focus. But it absolutely has been something that's key. And they put in, within the first 100 days of their time in office, they did launch this Employment Rights Bill, which snuck in just within those 100 first days of the time in office. And so here you can see the developments and the sort of development of that Employment Rights Bill through the various stages that are required to bring something into law. So the bill has gone through its first and second readings. It's gone through readings within the House of Lords. It's gone through all the committee stages, which is where things get debated and pulled apart and then put back together again. There's been reports from both the House of Commons and the House of Lords, and then a third reading. So we're now at the very final stage. And in fact, we're expecting royal assent any minute now. So by the end of October, early part of November, we're expecting that this Employment Rights Bill becomes the Employment Rights Act and is then in effect. But actually, even when the Employment Rights Bill becomes an Act of Parliament, so receives royal assent and becomes an Act of Parliament, it's not all coming in on day one. It's not that all the various changes to employment law provisions are all going to happen immediately. And there's actually going to be a roadmap for implementing these various pieces of change. And that's how I'm going to take you through the session today. I'm going to talk to you about what's coming, when it's coming, what's going to change in comparison to what we have at the moment. And then we're going to look at the practical things, the practical steps as employers, perhaps, or leaders within your organisations, you need to be thinking about in order to be ready for these changes coming into effect. So you can see that there are various different dates there as to when we're expecting things to happen. First and foremost, normally with employment legislation, we have 2 dates in a year where things happen and come into effect: April each year and October. And so the plan is for the Employment Rights Bill, when it becomes an act, to take place in those sorts of timeframes as well, so April and October, across 2026 and also then into 2027. And actually, it's quite likely that this timeframe will slip. It may be that there are changes to this roadmap for implementation and that some of those measures that are going to come in might be delayed, and it will take some time to see how that pans out. So let's start then with those provisions that are expected on or soon after royal assent. Now, as you can see there, what I'm doing with each of my slides so that you can hopefully visualize the changes that are coming is to set out what the current position in law is and then what the changes are going to be under the Employment Rights Bill. There is a lot happening, and so there is quite a lot for us to look at, and I'm going to cover as much as I can in the time that we have together, but there are huge amounts of detail behind each of these provisions, as you would imagine. But to start with, we're going to look at employee relations, so industrial relations and trade union activity. The current position is that there have been some minimum service levels that were put in place for key public services. And they were put in place by the previous Conservative government in an attempt to try to quash and reduce some of the significant strike action that was taking place in the public sector. So we had striking teachers, junior doctors, train drivers, all sorts of strikes that were taking place, particularly in the sort of final throes of the Conservative government. So they introduced minimum service levels with a view to trying to prevent everybody within those different sectors being able to walk out at the same time. Those were not popular with the Labour Party, and so those are to be repealed. And that will take effect as soon as this Act becomes law. Various other provisions within the Trade Union Act of 2016 are also largely repealed. There have been some ballot requirements. So previously there has been a minimum turnout threshold for industrial action. So if a group of employees wanted to strike, they needed to be able to show these various different thresholds. And 50% of eligible members had to be able to vote, or had to vote, in order to be able to at least go through to any industrial action. That is being repealed. And these various changes are designed by the Labour government to try to simplify ballots, to simplify the ability for trade unions to be able to encourage strike action and to get strike action off the ground. There's going to be a repeal of some different requirements of union supervision on picketing and strengthening protections against dismissals where people might have engaged in industrial action. So if someone's actually taken strike action, they will be protected from being dismissed because of that. There is going to be changes to the ballot requirements as well. Minimum notice of industrial action is going to be reduced to 10 days. So as you can see, there are lots and lots of measures that are changing to do with trade union activity. And if this is an area that's particularly relevant to you and your business or your organisation, then this is something that you might want to be thinking about. And in terms of what can you do and what can you prepare, well, I think the concern is that actually with the strengthening of protections for trade unions and their members and the revision, the simplification of some of the ballot and strike action processes, it might mean that there is more frequent industrial action, that it can be called at shorter notice, and that once a ballot has been agreed upon, it can last for longer. So there's some more changes as well, which I'm going to talk about later in this session. So all in all, this means that you do need perhaps to be prepared for the possibility of greater strike action and more frequent strike action. That means you want to be trying to engage in good dialogue with any existing trade unions right now. That will help if you can get a great relationship or as strong a relationship as you can with your union. If you're a unionised employer, then that would be really helpful. And you might need also to be looking out for consultations on all the various other aspects of the bill, which are due imminently. Okay, so the next thing then is to look at the provisions that are expected in April 2026. So these are the next phase provisions really on this roadmap of implementation. And the first one there that I just want to draw your attention to is the changes to statutory sick pay. This is a change which means that at the moment there is a waiting period. If somebody is off sick, there is a 4-day waiting period, sorry, a 3-day waiting period, and they only get statutory sick pay from day 4. That is going. So sick pay is going to be payable from day 1 of somebody's sickness. That's quite a significant change for some employers, although of course for some where they might operate more generous company sick pay arrangements anyway, it might make no difference. There's also going to be a removal of the lower earnings limit, which is currently £125 per week, and that employees have had to earn at least that in order to qualify for statutory sick pay. That's going to change. So it's going to be paid, statutory sick pay will be paid at the lower of either the applicable flat rate, which is currently £118.75, or 80% of average weekly earnings. But remember, the key point is that payable from day 1. Another change coming in April 26 on this roadmap is changes to collective consultation provisions. Now, what I mean by collective consultation is where somebody is, an organisation is proposing to make changes, either redundancies or perhaps proposing to dismiss and re-engage employees because they're trying to bring about changes to terms and conditions. There is an obligation where that's going to affect more than 20 people, 20 or more people, there's an obligation to collectively consult about that rather than just carry out individual consultation. And there have been various things that have been discussed in the original version of the Employment Rights Bill that seem to suggest that it was going to be even harder for larger employers here, because at the moment the law talks about 20 or more redundancies or potential dismissals at one establishment. And if you're a group of companies operating across different different geographical areas perhaps, or different entities, then you used to be able to say, well, actually, this is not all one establishment. And there was a concern that the government were going to scrap that ability to talk about establishments and look at the entire organisation as a whole. That was very unpopular through the consultation process of this bill, and it is now being agreed that the one establishment test is going to remain. There is going to be potentially new thresholds, though, introduced based on redundancies across an employer's organisation that might be linked to a percentage of total employees or a specified number of employees. That's still up for consultation, and we're not going to find out about that. And it won't come in until at least 2027. If you do not properly collectively consult, the penalty is doubling. So it was a penalty of 90 days gross pay as a protective award to each individual who may have not been collectively consulted with. That's going to increase to 180 days gross pay from April 2026. So a big change on the penalties. Next, some more changes around the trade union recognition side of things. Again, I'm not going to go through each of these in detail around the trade union points, but you can see there that, again, it's all about trying to make it easier for unions to get a foothold within an employer. So if you're not an employer that currently recognises a trade union, it is going to become easier for trade unions to try to ballot for recognition. There is going to be a removal of the 40% voting threshold, so it will simply be a majority that need to vote in favour of recognition. And then there'll be strengthened protections against unfair practices by employers. So it all, again, just strengthening and strengthening the trade union's power within a workplace. It will also bring in some more changes to do with the balloting of workplaces, and there's going to be a repeal of this 50% turnout threshold that was in existence before. And whilst there hasn't been an automatic right for trade unions to access workplaces in the past, there is going to be strengthened opportunities and a statutory process allowing unions to access workplaces. We'll see exactly how that's going to work in due course, as it's part of consultation at the moment. But it is all about strengthening that union involvement. Some other key measures expected in April are set out there. So changes to parental and paternity leave so that it becomes a day one right to paid, statutory paid paternity leave and unpaid parental leave, but both coming in from day one. There is going to be some protections around whistleblowing. So if somebody were to make a report of sexual harassment, that will now be deemed to be a protected disclosure under the whistleblowing legislation, which means that there's an additional degree of protection for people not to be subjected to a detriment or dismissed because they've blown the whistle for that purpose. And also, we're expecting a Fair Work agency to be established. Not really clear exactly what powers this agency will have, but it's really to try to bring together the various different enforcement agencies that currently look at the national minimum wage, holiday pay, statutory sick pay, and the gangmasters and modern slavery organisations. So it's a body to try to simplify and bring all into one place some support for those particular areas. We'll yet see how that will work. So again, what should you be doing? What are the practical steps, things you ought to be thinking about? Well, you ought to be reviewing and updating your sickness absence policies, ensuring that people know, that managers know that statutory sick pay is going to be a day one right. That encourages or should encourage managers to take more proactive steps in managing short-term absences or persistent absence, because it might have an impact on the amount of sick pay that's being paid by the organisation. Be really careful about collective consultations. Be ready to engage and to carry out very careful collective consultation in order to avoid that doubling of the protected pay award. And given that there's going to be changes to enable or to prevent actually your ability to dismiss and re-engage employees, that fire and rehire process, if you're looking at changing terms and conditions, that's going to become much harder. And I'll talk about that a bit later because it's coming in, not in April, but later on. So you ought to be thinking as well about, are there changes that you need to think about in your organisation now? Because if there are, now's the time to do it before you're precluded from doing it at all, from dismissing and re-engaging. Think about your trade union activity in the way that I've mentioned before. Think about the fact that it might be more possible for a trade union to become recognised. So you might like to start thinking about whether or not you've got good employee engagement already. Do you need to put in place, or might you think about some sort of representative bodies within your organisation that might mean employees already feel really engaged and able to speak to management so they don't need a union to turn to? That might mitigate the risk of a union getting a stronghold. And also review and update your family leave policies to reflect that day one right to statutory paternity and parental leave. Next, on this roadmap that we're going through, as you can see, there are significant changes, aren't there? This is a lot to take on. So it's really important to try to think about it in stages. You don't have to do everything right away. But the next stage is coming in October of 2026 are as follows. So I just mentioned dismissal and re-engagement, or fire and rehire as it's sometimes referred to in the press particularly. You may recall the P&O ferry issue that happened a few years ago, to much outcry in the press. And it was on the back of that the government, the Labour government, said that they would ban fire and rehire as a concept. Now, this is the idea that in order to change somebody's contract of employment in law, you either need to get that employee to agree to the change, or you have to dismiss them and end their current employment and then re-engage them on new terms. Because actually an employer doesn't have the power to just unilaterally change somebody's contract in law. There are only those two ways of doing it. One, by agreement, or secondly, by dismissing and re-engaging. And it's this dismissal and re-engagement that has been really unpopular. So already, before the Conservative government left the government, they had put in place a statutory code of practice, which provided that if you didn't follow these additional steps to try to really look carefully at collectively consulting and trying to involve ACAS in any dismissal and re-engagement process, there was an uplift in compensation that could be awarded. Now it's going to become automatically unfair to dismiss and re-engage from October next year. Really, in very, very, very limited circumstances, will it be fair to dismiss and re-engage. And really, what seems to be the case is that you can only do it in the future from October next year if the business is facing severe financial difficulties. And really, if you're going to be not able to continue as a going concern, might you be able to look at changing terms and conditions in this way? So for all but the most serious situation that facing an organisation of potential insolvency, it looks as though it's going to be very, very difficult to use dismissal and re-engagement in the future. There's going to be a revision to the Code of Practice, and that maximum protective award that would be payable if you fail to follow that new Code of Practice and the provisions around collective consultation will be increased to 180 days pay, just as I mentioned earlier. So this really is quite a significant change, and one that you really need to take very great care over. There are some changes around harassment as well. So there's going to be a duty to take all reasonable steps to prevent sexual harassment. Since October 2024, when the law changed to say that an employer must take reasonable steps to prevent sexual harassment, we've been grappling with what is a reasonable step to prevent harassment, and there are various pieces of guidance on the Equality and Human Rights Commission's 8-step plan that you might want to consider. But this is going to be extended even further from October next year to take all reasonable steps. Now, there's going to be an ability for the government to specify what that really means, what all reasonable steps means. And there's also going to be a duty to take all reasonable steps to prevent third-party harassment as well. And that's going to apply to all different protected characteristics under the Equality Act, not just sexual harassment. So lots to change there in the harassment sphere, and it's something to be very, very aware of and to be making sure that you are training your employees about, so that everybody understands what's expected of them and expected that they shouldn't do in terms of harassment. And there's lots of other steps to take too. Again, more on industrial relations and trade unions. There's going to be a right to a written statement of trade union rights that's set out in people's contracts of employment. And you'll see some other aspects there that are going to be put in place, enabling trade union officials to be able to have access to facilities like photocopying and a place to have meetings in the workplace, perhaps, and time off and the ability to have time off to support their members. And also all underpinned by protections against any detriment that they might suffer for having taken industrial action. So these are all substantial changes again. Some other measures as well coming in October 2026. The time limit for bringing an employment tribunal claim is going to increase from 3 months to 6 months. So that means that it's going to be a little bit harder. It will take a bit longer for you to feel safe, perhaps, that an employment tribunal claim isn't going to be raised against the organisation when somebody has either left or when some act of potential discrimination might have occurred, from 3 now to 6 months. There are some new rules about tips, that an employer is going to be required to consult about any tips policies and then review that policy every 3 years. There's going to be changes to the public sector 2-tier code of practice. Again, if that's relevant to you, that's something that you might need to be thinking carefully about. And some changes to do with fair pay agreements, particularly to do with adult social care negotiating bodies and support staff negotiating bodies within schools. So again, the practical things, what should you be doing? Again, these are things that are not coming in until later, so October 2026. You've got some time for these. But right now, I'd say make sure you're reviewing your contracts. Are there any contractual benefits that you actually are concerned you might not be able to continue with? If you think you need to make any changes, then start thinking about that now. Start looking at whether you're going to need to collectively consult to dismiss and re-engage on new terms before you're not allowed to do that anymore. Tighten up your processes for dealing with harassment. Really think about making sure your training is appropriate and up to date. Carry out risk assessments, and if you need any help with that, then please do get in touch. There's lots to think about. If you're in the hospitality sector, think about your tips policies and schedule reviews for that. And again, trade union activity is ongoing. So just think about how you might ensure that you're going to comply with all of those new duties to inform workers of their rights to join trade unions, and making sure that employees are not penalised if they are taking part in industrial action. Then looking even further ahead to 2027, there are some other provisions that we're expecting to come that are going to happen in the future. So what are they? Well, the one that really is being talked about particularly is the changes to the qualifying period of service that somebody might need to have in order to bring a claim for unfair dismissal. I just thought this chart was quite useful, actually, to show you the changes over time since 1971, where people have had to have varying different levels of service to be able to bring an unfair dismissal claim. And you'll see the lines in blue are where we've had a Conservative government who have tended to require a longer length of service before somebody can bring an unfair dismissal claim, versus a Labour government when actually very often they reduced the length of service required. So you can see that there's changed up and down over the years. But in 2027, we're expecting a change, which is the big thing that was actually really one of the headline grabbers when the Labour government announced this employment rights bill at all, and that was the day one right not to be unfairly dismissed. This is going to be a substantial change so that people can have all of those rights and protections from not being unfairly dismissed right from their very first day of employment. Now, people have lots of rights from their first day of employment, or indeed even before they become an employee, under the Equality Act, from not being discriminated against, and various other aspects around controls about whistleblowing and things. But straightforward unfair dismissal claims have required 2 years service at the moment, but that will be becoming a day one right. What we understand is that there's going to be some kind of initial period of employment where there's going to be a modified process, like a probationary period, but set out obligations on an employer to meet various different processes in order to be able to dismiss within that probationary period. There's likely to be a cap awarded for dismissals within that initial period of employment as well, and it's going to be subject to separate regulations. We're also expecting that the ACAS code on disciplinary and grievance processes will be reviewed and revised. So this will be a substantial change. There's also going to be some changes to guaranteed hours. This was another area where the government was particularly determined to try to protect those employees and workers who they consider to be being perhaps not looked after as much as they might be. And it's all to do with 0 hours workers and those who are perhaps low hours workers. So there is to be an offer of guaranteed hours, which would reflect the average that somebody has worked during a reference period looking back in time. And the suggestion is that that would be looking back over a 12-week period. This is going to be something which really needs to be worked out through consultation and through secondary legislation to try to help really set out how this guaranteed hours process is going to work. So we wait to see how that's all going to work, but there is going to be additional protections for employees or workers about having the ability to say if they've been prevented from having these guaranteed hours. And there's also likely to be a right to a reasonable notice of shift changes or cancellations of shift. And if you don't give that reasonable notice, then there's likely to be a penalty that would be payable. So again, these are things which are yet to be completely worked out, but they are, again, changes to be aware of. There is going to be a new right to unpaid bereavement leave, which is going to be of at least 1 week, and it will apply to relationships with loved ones. Now, this is all part of a current consultation that's literally just been announced in the last few days to look at what does loved ones mean, what's the extent of that relationship that's going to be required so that somebody can have this right to unpaid bereavement leave. Now, of course, lots of employers will already be offering compassionate leave, which far outweighs the statutory right that will be put in place. But this is also going to cover pregnancy loss before 24 weeks, and it will be a day one right. There's going to be some changes to flexible working from 2027 as well. It will remain only a right to request to work flexibly, not an actual right to absolutely work flexibly if that's what somebody wants, but there'll be a new requirement of reasonableness if you're refusing a request to work flexibly, and an employer is going to have to notify the employee of all the grounds why that refusal is reasonable. There will be the same statutory reasons to refuse, so we understand, but it is something that might make it a little bit harder for an employer to be able to turn around to somebody requesting flexible working and turn it down. I'm not going to take you through each one of these in turn, but I'll leave those sitting there on the screen for a moment so that you can see some other measures that are expected as well from 2027. So significant other measures around protection for flexible or for family working, family leave, pregnancy and maternity leave, and harassment. And then again, the requirement on an employer to start looking at equality action plans. Some strengthening protections around blacklisting, and also a broadening and expanding of the definition of an employment business when looking at agency workers. So there's a lot to take in. I'm really conscious that that's been a bit of a whistle-stop tour, but I hope it's shown you the roadmap that is in place for the Employment Rights Bill, that there are a whole host of things that you need to be thinking about, but not getting overwhelmed because they're not coming in all on day one. These are going to be an array of changes that are staggered over the next year, 18 months, and potentially even longer than that. So lots to think about, but it's a measured approach. So just start reviewing your processes and policies. And if you require any assistance, then of course, please do take advice on those. Some other aspects as well, just to conclude, non-disclosure agreements are being looked at. And this is a potentially tricky area where currently an employer might want to enter into a settlement agreement with somebody who might have raised potential for a claim, and it's going to be much harder, if not impossible, to put in place confidentiality wording, which would prevent an individual going and talking about harassment or discrimination, other than in very, very limited circumstances. So that's something, again, to keep an eye out for. We don't have any implementation dates for these issues at the moment. They're just things that were mentioned in the Employment Rights Bill, but that we don't have any dates for. Same to do with some changes for working time obligations about record keeping and keeping those records for 6 years. Again, no implementation dates for these yet. And potentially some requirements for employers, larger employers, to publish equal pay information to do with outsourced workers. But again, no implementation date for that either. Okay, so that brings me to the end of the material that I wanted to cover with you today on the Employment Rights Bill, although it is worth saying that this webinar has been recorded on the 5th of November. And that means that the content and the update that I've provided is correct as of that date. But this is a really, really continuously moving area. And actually, the House of Lords have pushed some of the amendments that they had requested back to the House of Commons again. And this is called the ping pong process. It's pinging and ponging back between the House of Lords and the House of Commons. And in fact, on the 5th of November, at some point during the day, Parliament are due to be looking again at some of those requested amendments by the House of Lords. That means that in particular, one of the issues that the House of Lords is really thinking about is the day one right to unfair dismissal protection. This was, of course, the one that I've just spoken about as being a real manifesto pledge by the Labour Party, that they would give this day one right to not be unfairly dismissed. The House of Lords are very keen that this changes to 6-month protection. So from 6 months of employment, somebody would have those unfair dismissal protections, going down from the current 2 years that people have to wait at the moment. So this is something that the Commons are going to be looking at again today. And it may be that when you're listening to this, this webinar on Monday, the 10th of November or afterwards, the Commons may have accepted that amendment that's been proposed by the Lords. Now, it was a manifesto pledge by the Labour Party to have this day one right to unfair dismissal for everybody who's an employee. So it will take a lot for the government to decide to move away from it. But given the economic climate and the pushback that they're getting from businesses and from the House of Lords on businesses' behalf, it may just be that a change comes through in the sort of final stages of the passage of the Employment Rights Bill. So it's really important to watch this space. And if you want to get up-to-the-minute updates on what's happening with any area of employment law, but certainly on the Employment Rights Bill particularly, then what you've been seeing on your screen just now is the QR codes for Birketts Employment app. This is something that you can have up-to-the-minute updates on employment law matters on your mobile device. So please do feel free to sign up to this free app. It's a really great way of keeping up to date. So we'd be delighted for you to scan those codes and be able to use that app. So as I say, keep an eye out as the law continues to change. And then that really does bring me to the end of our session today. But from a questions and answers point of view, what I would really encourage you to do is that if you do have any particular questions arising out of anything that I've spoken about today, please feel free to pop that in the chat function on today's webinar. And then we will get back to you. A member of the Birketts team will be in touch with you to try to answer your query. Now, of course, if they're queries which are very fact specific, we might not be able to give huge detail in a response to you, unless, of course, you'd like to get in touch with us for a more detailed piece of advice. But otherwise, we'd be very happy to answer any queries you have on that Employment Rights Bill update that I've just provided you with. So please do be in touch, and I hope that you found that useful. Any questions in the chat? But thank you very much for your time today.